Friends, at a particular age of one's life, everyone searches answer to one very important question, and that is it better to distribute the assets during one's lifetime or after a demise? Which succession tool is best suited to a person's needs? It is because more than 75% of the court cases in our country are about family and property disputes, and also about 65% are only property disputes. Many of these family and property disputes, friends, can be attributed to absence of a will or a testamentary ambiguity, as we call it. So every well-intentioned or a knowledgeable person would definitely like that he should ensure that after his demise, his property owned by him or assets created by him in lifetime are shared among his successors as he may wish, and there doesn't arise any disputes among his successors, etc. etc. Before answering this important question, one has to know about the succession laws prevailing in our country. A person, when dies without writing any document, that is a will, is called having died intestate. So if one dies intestate, all his property or assets, liquid or immovable, everything will be dealt with as per the succession law applicable to the religion of the deceased person. For example, Hindus, Buddhists and Jains are governed by Hindu Succession Act 1956. And for Christians and Parsis, it is Indian Succession Act 1925. Muslims are dealt according to Muslim Personal Law Shariat Application Act 1937. We will discuss in some other video about Hindu Succession Act in detail because it is an elaborate act which deals about settlement of a person's asset dying intestate, that is without writing any will or leaving any testamentary document. So let's first talk about will. Will or a wasiyat is a document written and registered by the testator. Testator is a person who writes a will during his lifetime, read and implemented after the death of the person or the testator. The beneficiaries need to get the will probated in the court to get it executed. Here the testator has exercised his power and chosen his inheritors as per his their will and wish. Because it is read after the demise of the person or the author, a word of caution here is that will must be drafted very, very carefully and got witnessed by two persons and got registered in the office of sub-registrar. Its contents must be unambiguous. Though a will is universally acclaimed for its efficacy, it can still be contested and can trigger family conflicts after one passes away because it is read afterwards. Is it then better to distribute your assets while one is still alive, or should one resort to instruments other than will? So what are other tools available? Number one is gift. Gifting assets can help